share that.
Are we sure to share?
Well, I am left with the daunting task of trying to pull what we've heard together. Those of you who have sat in this room when I've taught understand that I also am not going to use technology because you know how incompetent I am with the technology. I want to do essentially three things in the next few minutes. One is I'd like to try to put the phenomenon of outside pressure on law school clinics into some broader context. Second, I'd like to talk a little bit about some First Amendment questions that are lurking in the background here, and then I want to come back to the question that Peter Joy touched on briefly, and Adam also alluded to, the question about how does academic freedom fit into this picture. These are questions more than answers, but I think that they may help bridge this session to what follows for the rest of the day. Let's think first about putting this into some context. The idea that people in law schools who do work, take cases, get involved in public controversies, is limited to law school clinics, I think is not entirely accurate. During my first week in law school, one of our faculty, a very distinguished evidence scholar, was installed in an endowed professorship. And at the installation ceremony, he told a story about the Chicago 7 trial. It seems that one of the defendants was a graduate student at the university, and the student came to him and asked whether the professor, who was already a fairly prominent person, would represent him at trial. Now, those of you who remember the Chicago 7 trial know that some of the more prominent defendants thought that this was a political trial and that they were going to engage in guerrilla theater tactics in the courtroom. The professor told the student, I think you have a very good legal defense, but if you want to do guerrilla theater, you need a different lawyer. The graduate student decided he'd play it straight, and he was acquitted. But the case generated a huge amount of controversy in Chicago, both because of what had happened in 1968 at the Democratic Convention and because the presiding judge at the trial, Julius Hoffman, was a very prominent alum of the school, indeed so prominent that a classroom in the law school was actually named after him. And so the university and the law school were subject to a lot of pressure from people who were outraged at the very idea that a member of the faculty would be involved in such a case, and making all manner of dire threats about withholding funds and other things. And as the professor said at the installation ceremony, to their everlasting credit, the dean of the law school and the president of the university told all of those people, in effect, to go jump in Lake Michigan. I'm sure there are other stories like this around, but it does seem to me that we should remember that it's not just clinicians who can, and clinical students, who can get into controversy. So that's one piece of the context. Second piece of the context. Both Peter and Adam have talked about the notion that attacks on law school clinics are, in effect, attacks on people who would not otherwise have legal representation. So by de-lawyering their efforts, it is possible for people who want to go forward with various projects and policies to do so with relatively few obstacles. This also is not new. Last Sunday was the 50th anniversary of the Supreme Court decision in Gomillion against Lightfoot, which was the Tuskegee gerrymandering case. But Gomillion was decided and arose during a period of great efforts by various Southern governments to try to kneecap the civil rights movement by making it impossible for the NAACP to function. The theory was that the NAACP was stirring up trouble among otherwise happy people who were being led down the primrose path. So, for example, in Alabama, the legislature passed a bill requiring the NAACP to turn over its entire membership roster, or its entire in-state membership roster, to the state, on the theory that the NAACP might have been infiltrated by communists and other subversives. So the state, on this view, was doing a service to the NAACP by helping them to root out these bad people. Well, of course, everybody understood that the whole point of the exercise was to give the state and private groups acting in league with state officials the opportunity to harass people who belong to the NAACP. A number of states passed laws prohibiting members of the NAACP from serving as public school teachers and holding other kinds of public employment. And Virginia, to get back to the analogy here, Virginia passed a law that essentially tried to bar the NAACP from participating in litigation on the theory that the NAACP was controlled by lay people, and therefore if the NAACP was conducting litigation, the organization was engaged in barratry, and the citation for this is NAACP against Button, in which the Supreme Court struck down that law. So we've got that example. And then at a more general level, Peter talked about, if you remember, if we're old enough to remember these things, well, some of us may also be old enough to remember the old Community Action Program, which was at the center, it was one of the centerpieces of the war on poverty in the 1960s. Well, the Community Action Program didn't do a lot of litigation, but it stirred up a lot of political trouble for some politically prominent folks like Mayor Daley in Chicago and people elsewhere. And eventually, the Community Action Program was domesticated or defanged or whatever. But again, the theory was that this was a device for empowering people who were relatively powerless, and that served as a kind of threat to the powers that be. So when we think about the pressures that law school clinics face, we ought to think about them in larger context. This is not new. It's a variation on a theme that has been with us for a while. Now, let me talk very quickly about a couple of First Amendment cases that might bear on at least some of the work of some law school clinics. First, when we think about public law schools as opposed to private law schools, we need to think about Garcetti against Ceballos. Garcetti against Ceballos is a 2006 Supreme Court decision which basically says that public employees do not have First Amendment rights against discipline or regulation when they speak on matters relating to their employment. The opinion is written quite broadly. The case actually involves an assistant district attorney in Los Angeles who got in trouble internally for questioning the adequacy of the documentation underlying an application for a search warrant. But the Supreme Court said that because he was speaking about the search warrant and the evidence in connection with his official duties, he didn't have First Amendment protection against discipline. It's not clear how broadly we should read Garcetti, but we ought to be sobered by the fact that although Justice Kennedy's opinion says we are not addressing whether the rule we lay down in this case applies in academic institutions, lower courts have generally taken a very cramped view of the First Amendment rights of teachers and professors. Earlier this year, for example, the Second Circuit decided a case in which a New York City school teacher was fired because he had filed a complaint that his principal had not adequately backed him up in connection with his efforts to deal with a disruptive student. He didn't get anywhere with that, so he filed a grievance. For filing the grievance, he was fired. The Second Circuit says under Garcetti, this is related to his employment, and therefore he has no independent First Amendment protection. Now, how much beyond that we will go, who knows? Sitting in the back of the room is one of our law review associates who was actually writing his note this year on precisely that question. And so let's just say I will look forward to seeing what you come up with, Ben. Okay. Okay. So there's at least some question about whether clinical teachers at public institutions could assert some kinds of First Amendment defenses, given that what your job is as a clinician is to go out and work with students and represent clients. So a broad reading of Ceballos might suggest that the First Amendment offers little or no protection for clinicians at state institutions. Whether we're talking about public or private institutions, some clinics receive some government money. And to get us back to the government speech theme, the government might assert that restrictions on what clinicians or law school clinics can do to the extent that they are publicly funded might involve government speech. That is, the government has a message that it's trying to convey, and under cases like Rust against Sullivan, the government has the power to limit the speech of grant recipients to make sure that the money that the government provides is going for its intended purpose. There is, however, another case that may be helpful on this one, and that is Legal Services Corporation against Velazquez, which was decided in 2001. The Legal Services Corporation, for many years, and there's been, Peter alluded to this earlier, the Legal Services Corporation for many years has operated under legislation that limits the kinds of lawsuits that legal services funded agencies can bring. Velazquez challenged the provision that prohibited legal services funded agencies from challenging welfare laws and regulations. It wasn't quite as sweeping as this bill that the 549 to which Adam alluded, but I guess under that restriction, you could mention the Constitution, you just couldn't do anything with it. Legal Services Corporation argued under cases like Rust, well, this is government speech, we can limit the uses of the money. The Supreme Court says, not so fast. It is true that there is government money here, but it is also clear that this money is not being spent to convey the government's message. Rather, this is a form of subsidy of private speech, and therefore the restriction on the kinds of welfare cases that can be brought violates the First Amendment. So if Garcetti is a bad sign for First Amendment protection for law school clinics, Velazquez at least suggests that there's something on the other side. And maybe we can talk more about that in the next few minutes in the discussion and through the rest of the day. I want to take just a couple of minutes to talk about the academic freedom argument because, as Peter said, the Supreme Court has a line of cases in which it says that academic freedom is a special concern of the First Amendment. What's interesting is that in many of the cases in which the court rules or says that academic freedom is an important First Amendment value, the claim gets rejected on the merits. Academic freedom is a very complicated subject. It does obviously have First Amendment concerns, but it's complicated in a number of ways. There's an individual component to academic freedom, that is, what an individual teacher or scholar can do in the pursuit and dissemination of knowledge, but there's also an institutional side of academic freedom. That is, to the extent that academic freedom is an institutional phenomenon, it protects the institution from external constraints. And for law school clinics, it's the institutional side that really matters. But even on this side, it seems to me that the question about how academic freedom plays in the law school clinic context is complicated. And it's complicated because of the nature of law schools, not just clinics. The overwhelming majority of American law schools now are affiliated with universities. Still some freestanding ones, to be sure, and some fine freestanding law schools, but most American law schools are part of universities. We also have a kind of odd relationship to the university. We are not the kind of classic science or hard science or natural science or humanities discipline where we're just out to find and produce and disseminate new knowledge. We're also in the business of training lawyers. Any of you who have been both to graduate school and to law school will know that there is a huge difference between what happens in law school and what happens in graduate school. And it's not just that we have huge classes and the professor stands in the front of the room posing a bunch of unanswerable questions. The fundamental difference, I think, between law school and graduate school is that in graduate school, the presumption is that all of the students want to grow up to be like the teachers they work with. Doesn't always happen, but that's kind of the presumption in most graduate programs. In law schools, even law schools that produce a significant number of law teachers, the great majority of the students never go into teaching. The idea is we're going to go out and do something different from what the teachers are now doing, even if what we will be doing is what the teachers, or a lot of them, had done at some point in their professional careers. And so that seems to me to at least raise the question, what does it mean to talk about academic freedom in law schools, and particularly in clinics? I don't raise this to say that it's clear that even if academic freedom applies only in a limited way in law schools, that therefore external forces should be able to make whatever sorts of regulations they want. I simply want to suggest that whatever it is that law schools are about, it's not the same thing as what the biology department or the math department or the political science department or the history department or the English department is about. And so as we think about how academic freedom applies and whatever First Amendment component it has, that First Amendment content is more complex, it seems to me, than the way academic freedom plays out elsewhere on campus. Maybe doesn't lead us to a different outcome, but at least makes the path to arguing that external restrictions on law school clinics are sufficiently suspect that we resort in the first instance to arguing that we have academic freedom problems. I haven't sorted out how I think about these things. I think that these issues are hard, and I think that may be one reason why, as Peter says, the cases that have challenged external restrictions, to the extent that they've won, they've tended to win on grounds other than the First Amendment. So perhaps I've done my job as a law professor by asking more questions than I've answered. I'm looking forward to the rest of the discussion, and thank you for your patience. So.
We really did want to give everyone an opportunity to participate, but maybe first, if Peter or Adam have any response.
Right. Actually, I do have one response on one thing with John. I was always, as a law student, the kind of student that didn't necessarily agree with everything a professor said. So, and I basically agree with everything except one piece, which I didn't make clear, and I'm hopeful that there'll be some progress in this. But when John said that a law school clinic and law schools aren't exactly like the biology department or English department or something like that, I mean, I think you're basically right, but I like to think of the law school clinic like the biology lab, all right? The same way that you might have some kind of biology course without a lab, which would be the rest of law school courses. And in the lab of the law school, the cases that we have, the clients that we have, that's really the textbooks that we're working from. And so the choice of cases, as long as they're within whatever the clinic you have, like Judy works in the criminal justice clinic, that those kinds of decisions are the same kind of decisions as choosing a textbook. Now, this isn't some crazy idea. And the reason why I say it isn't a crazy idea is at least the AAUP has taken that position. Now, of course, I was writing an amicus brief for the AAUP in which we advanced that position, so, you know, it could be that I've infected that notion. But I'm hopeful, too, that in a recent article that's coming out in the AAUP magazine Academe, Bob Kuhn and I suggest that what's happening to law school clinics, you know, could be something, you know, we use the word like a bellwether for what might be happening to service learning courses and other kinds of courses. And there are some other instances. So, for example, labor courses in different departments, more academically oriented departments, or social work activities that students do where they might be doing some work with the community group, confront some of these same kind of questions. So the issue about academic freedom, not as a legal concept, but as a norm within educational institutions. And I want to make that distinction because academic freedom as a norm in educational institutions is a much stronger position than a concept in terms of a First Amendment right. And in that context, I think that what we find is a movement that academic freedom should be protected wherever teaching occurs, whether it's in the classroom, whether it's in the lab, whether it's in a service learning course, whether it's in a practicum of a particular field. And so it's not to say that I disagree with John, but it's just that I wanted to add that little bit more piece of information or nuance to, I think, what John was saying.
And let me just add, I mean, my focus was more on what a court would do with the argument.
Okay.
I think those of us who do constitutional law generally, I think, know that the Constitution has meaning that arises outside of courts as well as inside courts. And so, yeah, we need to recognize that, in a way, we've lost if these issues are in court. The way to really, and you know, that was the point of my telling the story about the professor with the chair, that if he can't count on support from the university, then even if he wins a lawsuit, his situation is very different.
Adam, did you want to
No,
jump in here? Okay. Yes?
Well, since I am a First Amendment person, my question is a First Amendment question. And it's along the lines of, what do you think of this? And it seems to me that Garcetti might be limited to the employer-employee context, since supposedly the justification for it was to give the public employers some of the same power that private employees have in disciplining employees that might be like disruptive to the efficient functioning of the workplace. And given that, maybe Garcetti isn't such bad news for this kind of situation.
Well, let me flesh this out a little bit. I mean, I think that may well be right. On the other hand, the legal profession is pervasively regulated by external agencies, particularly state Supreme Courts. I mean, part of what strikes me as problematic about what 549 is that it came from the legislature, but as you indicated, there were strict rules put down by the Supreme Court. It seems to me not that Garcetti by its own force leads to the conclusion that clinics may be vulnerable, but rather that this notion that the clinic as part of the profession is subject to external regulation may provide at least a little push for the argument that the court might be able, the state Supreme Court might be able to impose restrictions. I don't want to push this too far, as I said, because I agree with you that Garcetti is about something else. It's about the workplace. But it does seem to me that Garcetti, whatever you might say about it in general, reflects a notion that what people do in the workplace should be subject to some kind of hierarchical regulation. And that seems to me not necessarily to be a good thing.
Yes.
To follow up on Professor Corbin's comment, I think I agree with her interpretation of the case, but I also think that the Velasquez case, which is what I was thinking of from the first moment you got up there, is probably going to be very, very helpful because it is so much more specific to protecting the client-lawyer relationship. And in fact, of course, at the time, it was so surprising a case because Rust had just come out the other way, but they found, as justices, something very special about protecting that relationship. One thing I was kind of intrigued by is you said that some of the work that you do in Tulane is simply kind of day-to-day work versus this global issue. We're going to fight this new business that's coming into town. And I'm kind of surprised that the government didn't distinguish at all between those two types of cases. Because, of course, in the Velasquez case and what comes up a lot in the federal efforts to squash this kind of work is they don't do the issues work, and they thought it was fine to do the poor representation. So I'm curious if there's ever been any kind of distinction drawn by the legislature, or they're just out to get you all the way, no matter what you're doing.
Mm-hmm. Well, and by the way, I think I don't know how any of these cases work going forward, because we had Justice O'Connor for Velasquez, right? And so the world changes, right? But nonetheless, hopefully it won't be up there too soon. But I think it works much better for an argument like you're not allowed to mention the Constitution for a provision like that than it does for a provision which says something like you're not allowed to sue the government at all, right? I think. And now I think there are other problems with that, especially when it's not, then I think it's more of a First Amendment problem, I think, when the government doesn't actually fund the program at issue. But in terms of the kinds of work we do and the legislature drawing a distinction, I think from industry's perspective, and I should use that too broadly, because I've had people from big companies say to me, keep doing the kind of work you're doing, So it's not like it's a universal thing, right? But from the Taliban group of the industry, really anything which slows them down is evil. And so it doesn't really matter whether it's a precedent-setting case. If we're commenting on a permit and DEQ may stop, and DEQ is the Department of Environmental Quality in Louisiana, may stop and say, gee, we need a little bit more data to understand, those emissions based on these comments, then from the Louisiana Chemical Association's point of view, we have slowed down the permit and risked investment in the state of Louisiana, and that's just a terrible thing. So basically, they are against public participation in the permitting process. And that's the daily routine work we do.
And if I could add one thing, because although I didn't talk about the First Amendment cases, when I said things were murky, I meant it because I've read all of them, and so I'll use Velazquez to show you why, on the face of what you said, I think you're right, but if you dig a little bit deeper into some of these attacks, it doesn't come out the way I'd like it to. And the reason is this. In Velazquez, the court said, well, Congress doesn't have to fund a legal services corporation, but if you do, then there are some limits. So a lot of the legislation that's been proposed, and fortunately not have passed, would just totally deny funding. And that's something the state legislature could do. And now to move on to something that John referenced about the Supreme Court in their control of things. There was a case, I was on one of my slides, a Southern Christian Leadership Conference versus the Louisiana Supreme Court that went up to the Fifth Circuit. And in that case, what was being challenged were these more restrictive rules put on what law school clinics could do, kinds of clients that, well, actually not what they could do, but the kinds of clients they could represent.
Well, the solicitation.
In the solicitation,
Right.
well, a provision that if law students did a public interest information meeting about rights that people had, then they couldn't represent the individuals who might have gone to that meeting.
Although it didn't actually say that. It basically said if we solicited a case,
Right.
we could not assign a student to the case. So it burdened, if we exercise that First Amendment right,
Yeah,
if you accept that, to solicit a case, we can't assign a student to the
yes,
case.
but and I don't want to get into dispute, but the idea of do you solicit a case when you tell people you have these rights, and if you want representation, come to see us, or not, but without delving into the facts of that. Going back to what happened, it was very clear, and the court accepted, that in the district court dismissed this on a motion to dismiss. And so, you know, the standard on review, everybody remembers this, on review you have to accept the facts that were alleged. And there was an allegation of viewpoint discrimination. And the Fifth Circuit opinion says, well, even if the court did this in response to the pressure that the plaintiffs have alleged, they have done this in a viewpoint neutral way, and they've only done it prospectively. They've made it clear it doesn't affect any of the pending cases. And so even if there was bad motivation, in this instance, it's not going to count. Now, they did say, you know, the Fifth Circuit did recognize that this bad motivation in other areas of the First Amendment could be the lever that you could grab a hold of to try to get something declared unconstitutional, non-permissible. But in this context, that wasn't enough. So the only reason I'm pointing those two things out is that Velazquez, on the face of it, might provide some help in some types of legislation. That's the point that John made when he was talking. But there are other types of legislation, total defunding, that becomes more problematic. And also, although the legal profession is subject to the regulation of the Supreme Courts, when they act in this legislative role about the rules that they make, I think that the Fifth Circuit decision, you know, provides a little bit of a blueprint for if Supreme Courts, which primarily are elected in most of the states, I think 38 states, that if they were to be the pressure points as they were in the late 90s, that they might enact some restrictions that would be viewpoint neutral, would only apply prospectively, and that might provide some constraints. I think what the clinics in Louisiana have done is remarkable, because they've demonstrated that even within the number of restraints, the needs are so great that there's so many cases that are able to be handled, so many people that have justiciable claims that need to have those claims heard, that in reality, I think it's proven not to be the barrier that was feared, and and so it's you know, I think that's been great. On the other hand, because it hasn't been the barrier that industry wanted, they continue to come back with other ideas like Bill 549.
Could I just say a
Sure,
quick word
sure.
about that case? I think this is the Southern Christian
Right.
Association case. Fifth Circuit. One of the interesting things about the case is an illustration of something I tell my students about a lot, in my view, okay, and other people may differ with this, which is almost winning by losing, right? In that the plaintiffs in that case, who were clinic clients, some professors, lost the case on the merits. They got, they lose. But through the course of it, the Louisiana Supreme Court filed this trove of briefs explaining, well, this is why the rule regulates way more lightly than these folks are telling you it does. So essentially, in the best post hoc legislative history in the world, which is the Supreme Court telling the Fifth Circuit, and then on a cert petition, which was denied, but telling the Supreme Court, here's what the rule means. Essentially, they were saying, hey, this rule doesn't mean too much, right? These are the limitations. It's very narrow. And then as the rule was implemented in the state courts, all that stuff was actually very useful to me. So things that could have been read either way before that Fifth Circuit case were read consistent with the way the Louisiana Supreme Court had interpreted in that case.
Yes.
Yes, there are. It seems as if there are law clinics that the government likes to exist. Like the government may not have any objection to. In fact, that they may like law clinics that where the students help to prosecute international criminals and terrorists and things like that. So if the government likes some clinics, openly supports some clinics, but yet opposes other clinics by saying that it doesn't make their locality open for business, or isn't there cherry picking of the clinics, and shouldn't some clinics have the same rights as all the others?
Well, that's actually something that the committee members, when Senate Bill 549 was heard, at one point Senator Adley said, because there was all this talk about, well, how can we run a domestic violence clinic if we can't mention the Constitution? And Senator Adley said, hey, I'll amend the bill to only talk about the environmental law clinics, he said, public or private. Of course, there's only one environmental law clinic in Louisiana. And one of the committee members said, well, wait a minute. Now, so we solve your problem for you, and then somebody comes to me and says, I'm getting a divorce and my wife's not paying for a lawyer. Instead, they're getting these students. Or the DA's office comes to me and says, these students are filing all these crazy motions in our criminal cases. What do we do then? And so the Senate committee, that came up, and they seem to be taking that seriously, that if we're going to take people's lawyers away, if that's really the appropriate thing to do, why shouldn't we just take people's lawyers away instead of only doing it when it affects the chemical industry?
I think that'll be the last question right here.
Well, I'm wondering, since bar associations spend a lot of effort to encourage pro bono actions, have there been a likewise or any actions by bar associations, particularly in states like Ohio, where bar associations will investigate disciplinary matters, of looking at actions of governmental lawyers who use their power not directly to fight in a courtroom for under advocacy issues, but indirectly, threatening lawyers that your employer, your university will face my wrath if you take these actions. I'm wondering if these have resulted in any disciplinary actions by the bar associations that are encouraging the pro bono activities.
Okay. Well, I don't know of any disciplinary actions, but everybody who's a lawyer knows that bar investigations, unless they end up with some kind of public reprimand or public discipline, don't ever become public. I do know, kind of along the lines of your question, that both with the Maryland attack and also, I believe, with the Louisiana attack, though Adam could correct me if I'm wrong, but I know for sure with the Maryland attack, Carolyn Lamb, who's the president of the American Bar Association, wrote a very strong letter of support for what the clinic was doing. I remember that the time frame with Louisiana was a little bit short, but I believe that she did also. Sure she did, got that there, that so that the ABA has been very helpful. And I know that at different times there's been some support for the clinics in Louisiana from the bar associations in Louisiana back in, the 1990 matters. And I guess you could speak to that more in terms of what happened in 2010.
Right. In fact, our first witness in this committee meeting hearing was the president of the Louisiana State Bar Association, who personally had appeared on behalf of a defendant in court on the other side, and her testimony was, "Don't do this. This is not appropriate." And in fact, by and large, well, really without an exception, to my knowledge, now I've got no idea what everything that happened behind the scenes, but I thought the bar behaved very, very professionally throughout. I did not see the lawyers piling in and coming up and saying silly things. And in fact, right after the incident, the New Orleans chapter of the Federal Bar Association awarded the clinic its pro bono award for the year. So I feel the bar was very supportive. Now, Bob Kuhn, I don't know whether you were a co-author, wrote an article about
Yes,
using,
yeah, that's right.
About using, basically about whether or not lawyers who try to de-lawyer clients should be subject to discipline, which is an interesting article, but I view it mostly as interesting as something lawyers should read for their own self-reflection, in that, I think part of what's important in kind of making this process work is for the bar to view us in the clinics as part of them. We're helping them accomplish a purpose, which is pro bono representation. We're part of the club in a way. We're one of their colleagues. And I think you have to be careful about making the decisions about when to file disciplinary complaints, in that you can blow things up so that it's no longer a dialogue, it's a war, right? And as much as possible, I would like to see the bar basically stick together in these things. Obviously, the lawyers who directly represented the people who were attacking us were silent, but they were silent. They did, in other words, they weren't lobbing grenades.
Thank you. I think we have to end. I really want to thank the panel, and I know this conversation is going to continue all day.
Thank you.